Darroch and Her Majesty's Attorney General for the Isle of Man.
Now, before you begin, we don't have very long for this hearing. You've got an hour each and then a quarter of an hour reply. And what struck us is that while there are quite a lot of points, most of them are fairly straightforward arguments, one side and the other, and they're set out in your written cases. The one point where there might be quite a bit more to be said and where we would particularly welcome assistance is the new point that's been raised on behalf of a respondent about Section 2A10. Now, at the moment, we don't know what the appellant's answer to that point is. I don't know if that's been a matter of discussion, but subject to your own views, of course, we're inclined to think that it would be a good idea to spend a fair part of the hearing on that point. And it may make sense for us to hear the respondent first on that point and then hear the appellant in reply.
Certainly, my lord, yes. My lords, my lady, want the respondent to start on that point, or shall I deal with the other two issues that are raised in the amended statement of facts and issues?
We're wondering if it might, in the long run, make sense for us to hear the respondent first on all the points, and then hear you in reply. Would that be?
However, the court might.
Right. That's how we prefer it then.
I should say, for the sake of formality, perhaps my learned friend Mr. McGuinness, who's counsel with me, my learned friend Mr. Benson, or for the appellant, I appear for the respondent,
yes,
together with my learned friend Mr. Rogers. My lords and my lady have quite clearly seen there are three grounds of resistance. I will ignore the first two at the court's suggestion and come straight to the third, if I may. And in essence, as the court will appreciate, this was a point not taken before the Deemster. Indeed, in fairness to the Deemster, he was twice assured, I think in June and in July, at different hearings, that there was no time limit. In fact, there is a time limit because the relevant legislation says that any costs order should be imposed within 28 days of the confiscation hearing.
And as we understand it, it's deemed to be a variation of a sentence, effectively. Is that right? Well, maybe I should just let you take us to the provisions.
No, with great respect. Right. We would say whether what is said in the final trial level hearing is a variation attaches more to our first ground, right, namely that there was what we would characterise as a costs order on the day of sentence, and 10.5 months later there was an order made that costs should be paid of £175,000. So the debate and our first ground of resistance is a judge saying, yeah, there will be no order for costs then, and the prosecutor replying, no. Is that an order? Yeah. Because if it is, then it is, the court is, forgive me, in effect, functus. I yeah, lapse back into earlier language, and yeah, Section 56, the variation provision, doesn't apply. That's our first ground. The second ground is that we say the court also decided, and we draw my lords and my ladies' attention to a paragraph of the judgment, the appeal court also decided to overturn the costs order on the basis of fairness. It's true to say it's not articulated as abuse of process, it's not articulated as an Article 6 point, but nonetheless the court used the phrase, and this is in our case, in any event it wouldn't be fair to let the prosecution take advantage of Section 56 to amend it, because this was a deliberate decision which the court focuses on. So those are the first two grounds, that we defend the decision, as it were, of the Isle of Man Appeal Court on those two bases. The third point was not raised before the Deemster, it was not raised before the Appeal Court, or one must confess by the Appeal Court, but nonetheless it's a point we felt it proper to take, and my learned friend Mr. Rogers, who is a practitioner on the Isle of Man, I should say, was the person who knows this legislation and raised it within our team, as it were. My lords, my ladies, one does have to put together a number of bits of the Criminal Justice Act 1990. May I turn to that? It's at electronic bundle, page 149. The relevant sections start. 149, please. 149 has section 1, which is the basic power to make a confiscation order. Simply in passing, as it were, to avoid coming back to it, I would draw my lady and my lord's attention to the fact that section 1 speaks of a power rather than a duty. That may have a relevance later on when we look at sonegi in the Lords. But again, that's just to avoid coming back to this page again. Section 1 is the power to make a confiscation order. Over the page to 150 on the electronic file, or over the page in hard copy. Section 2A, subsection 1, gives the court a power to adjourn where a court is acting under section 1, considers it requires further information before deciding the matter. Then a few lines further down, it may, for the purposes of enabling that information to be obtained, postpone making that determination for such period as it may specify. So that's a power to defer making the confiscation order, and that is analogous to the English legislation. But then if we go down, please, to subsection 7, so further down the same page, please, 2A subsection 7, where the court exercises its power under subsection 1 or 4, which doesn't add much perhaps, it may nevertheless proceed to sentence or otherwise deal with the defendant in respect of the offence or any of the offences concerned. But we then need to go to subsections 9 and 10, 151 in the electric bundle, please. Subsection 9, in sentencing or otherwise dealing with the defendant in respect of the offence or any of the offences concerned at any time, the court shall not impose any fine on him or make any such order as is mentioned in section 2, 5b or c. And forgive me, in passing, that includes any order involving payment by him, which clearly would be a costs order. The court shall not make any such order.
Yes, so priority is given to the confiscation.
Yes, and then 10 we have the crux of it perhaps, where the court has sentenced the defendant under subsection 7 during the specified period. It may at the end vary the sentence by imposing a fine, and forgive me, that's how I unhelpfully misunderstood my Lord Reed's reference to varying the sentence. May vary the sentence by imposing a fine or making any such order, including costs, so long as it does so within a period corresponding to that allowed by Section 56 of the Criminal Jurisdiction Act 1993. That is elsewhere in the bundle. It's referred to a great deal, and that gives us 28 days. So there we have, seemingly, if one used the old nomenclature, seemingly a mandatory direction that the court it may do so long as it does so within a period corresponding to that allowed by Section 56. So it's tied to the slip rule, Section 56, which allows a change within 28 days.
Now Section 28 is, Section 56 of the 1993 Act, fixing the 28-day period for variations of sentence.
That's page 48 in the electronic. Forgive me, it's page 148 in the electronic bundle.
Now that corresponds to what's now, I think, Section 155(1) of the English Powers of Criminal Court Sentencing Act of 2000.
My Lord, it is. Actually, Section 155, if it matters, is in much broader terms, but it probably doesn't matter for this particular point. So my Lord's entirely correct.
And that provision has statutory history going back to the 1971 Courts Act. Section 11, right?
Yes.
And as House of Lords authority, to the effect that the 28 days is a strict time limit.
Yes, my Lord refers, of course, to the case of Menachal,
Yeah.
which said, and forgive me, I paraphrase it, I hope not too crudely, if you have a slip rule, you can't have a judicial slip on top of the slip rule. Parliament's intention in saying it may be varied within 28 days, or now 56 days, can't be read to say it may be varied within those days or whenever. It's clearly focused at imposing a time limit.
Yes.
So, my Lord, we do rely, my Lords, my Lady, we do rely on the fact that the linkage to Section 56 puts us in the position which we say is on all fours with decisions by the House of Lords in Menachal, which says a specific time limit section must be intended to impose a time limit by Parliament, otherwise why else would one have that section? Forgive me, that's my rather clumsy attempt to summarise the House of Lords decision in Menachal.
And if we're with you thus far, then I think a question then arises, which you raise in your written case, as to the effect, the relevance here of a series of decisions in the Court of Appeal Criminal Division in England and Wales about adjournments within the 28-day period.
My Lord, yes, entirely. The question could be phrased, are we within Senegi or not? And we would say we are not within Senegi, we are within Menachal for the reasons we've already...
Yes, I mean, Senegi is dealing, that's a completely different historical piece of legislation from the 28-day period, which the House of Lords explained in 1980, goes back to the old assizes.
Yes.
But when you refer us in your case to a series of cases, Gordon, Annesley, Constantine, which might be argued to enable the 28 days effectively to be extended.
Well, yes, and can I deal with them globally?
Really, just before you leave the statute,
of course, my Lord.
I must say I had some difficulty finding my way around all this, where simply it's really under 2.5b that any order involving a payment other than an order of compensation order includes an order for costs.
My Lord, it does.
Yes, I made the mistake of looking for some reference to costs, but you don't find it anywhere.
My Lord, we don't. And it is, may I say, in mitigation, not that he needs it, and my learning friend Mr. Benson of the defence and indeed of the Court of Appeal in the Isle of Man, it is not obvious. It is not
Matters obscure. And of course, your 56, which looks like opening a case for mistake, has got nothing to do with it. It's just the time limit there is brought in by a side wind.
My Lord, precisely so. It used the same time limit when, frankly, it could have used its own. But there we are.
Days, yeah.
That's
anyway, that doesn't affect the issue we're now on, which is can you extend?
I'm grateful. And my lady, my lords, in summary, we say the case of Constantine, with great respect, was wrongly decided, and the other cases which Constantine sought to rely upon, the common law power to adjourn a part of sentence, do not help the Attorney General in this situation, because they are all cases that do not apply where Parliament has seen fit to impose a statutory time limit. And perhaps I should then go, if I may, direct to Constantine. It starts at page 231, please, in the electronic bundle.
I'm working off the electronic bundle, so it's
231. It's tab C7, my lord.
Thank you very much.
That's 231. Constantine is a costs case. Constantine was a case where at first instance there had been no mention of costs, and then when costs were later imposed, the appeal was founded on an earlier hearing where they hadn't been mentioned at all. But the point perhaps that engages us is the one that is raised by the court itself in the course of argument. And if I can ask my lady and my lords forgive me, if I ask my lady and my lords to go to page 238, happily the paper and the electronic numbering is the same on this occasion.
I've got the number.
I'm grateful. It's 238. We've already recorded what the judge did, 238D, page 193 in the actual case. Forgive me, at 25, it's argued by Mr. Selleck, because the costs order under challenge was only made after the further hearing, which was more than 28 days. After the last day of the postponement period, in other words, more than 28 days after 10th of December, the costs order in respect to the proceedings other than the confiscation proceedings was invalid. He emphasised the mandatory terms of section 15.4 of the 2002 Act. And forgive me, if one goes back to paragraph 18, Mr. Selleck, counsel for the appellant, has had that drawn to his attention by the court in the course of the hearing, which we say is perhaps an indication that the court was unlikely to be assisted by full and careful argument because counsel, great respect to Mr. Selleck, hadn't spotted the point beforehand.
It might be helpful for us to look at the statutory provision that the court was dealing with here.
It might indeed.
I think we find it on page 236.
Yes, paragraph 15, thank you very much. Paragraph 15, page 235, I think, forgive me, of the bundles. The starting point is to examine the provisions of the Proceeds of Crime Act 2002, the relevant sections 13, 14 and 15. 13, if the court makes a confiscation order, it must proceed as mentioned in subsections 2 and 4. The court must take account of the confiscation before it imposes a fine or makes an order falling within subsection 3. Subsection 3 then tells us that includes an order involving payment by the defendant, so it includes costs, obviously. Subsection 5, forgive me, subsection 6, we need to turn to then 14, forgive me, section 14, postponement at the foot of the same page. The court may proceed under section 6 before it sentences the defendant for the offence or any of the offences concerned, or postpone proceedings under section 6 for a specified period. The period of postponement may be extended, and here we are in Senegi grounds.
And proceedings under section 6 are confiscation proceedings?
My Lord, yes, forgive me, yes they are. My Lord, we carry on, if we may, over the page to 236, please. And then we get, I think, the section that concerns the court the most. If the court postpones proceedings under section 6, it may proceed to sentence the defendant for the offence. Subsection 2, in sentencing the defendant for the offence, the court must not impose a fine, make an order falling within section 13.3, which we just looked at, which includes costs. But the court may proceed under subsection 3 only within the period of 28 days, which starts with the last day of the postponement period. So there we have, in effect, with respect, we would say, for our purposes, identical provisions to the one we're concerned with on the Isle of Man.
So section 15, subsection 3, again, treats the imposition of the costs order as a variation of sentence.
Yes, it does use that phrase, as does the Isle of Man legislation, as my Lord seized upon earlier on.
Yes, and so unlike the Isle of Man legislation, it doesn't incorporate by reference the general statutory provision dealing with sentencing variations, but subsection 4 adopts the same period of time.
My Lord, it does. There could be an argument, if we needed it, we'd submit with great respect, of course we don't, but if we needed it, that the incorporation of the time limit provision in the Manx legislation makes our argument a stronger one. But we would say, even on this, with great respect, we say the Court of Appeal fell into error. forgive me, my lords, at paragraph 18, simply as we are there, it's clear that it is the court that draw sections 13 to 15 to counsel's attention. He has an opportunity to consider them. His submission to us was that that's about the nature of, forgive me. He then argues that an order involving payment would not encompass an order not to pay costs, but that's a complication we don't need on this point. But then at 25, please, if we go back to 238, the court engages with this. It was argued by Mr. Selleck that because the costs order under challenge was only made after the further hearing for the judge, which was more than 28 days after the last day of the postponement period, the costs order in respect of the proceedings was invalid. He emphasised the mandatory terms of the 2002 Act. The court then moves on. This argument caused us some concern. The wording of section 15.4 is indeed mandatory. The Court of Appeal mentions the case of Menachal in the Lords, no power to extend the 28-day period in which it could vary or rescind a sentence. Could be argued the same principle should apply. The actual reason was to allow, I paraphrase, in research, and it's fair to say, as both counsel frankly admitted before us, no one, including the judge, had the terms of section 15 in mind. And then the crux of this, with respect, is paragraph 27 across the page, or forward to page 239. We have concluded the correct analysis is as follows. First, it is established by Hayden that an order that a defendant should pay all or part of the prosecution case is part of the sentence. Secondly, it's confirmed by Annesley and Gordon that the court has the power to adjourn the whole or part of the exercise of passing a sentence if necessary to do so. And then they deal with Gordon, which was about calculating time spent in custody. My lords, my lady, immediately after that, we have the Criminal Law Review report. And in the Criminal Law Review report, and forgive me, I don't go through it all because we've just looked at the case itself, but in the commentary at 245 in our bundles, please. About halfway down the page, there's a bracketed passage, and then it takes up just over halfway down that long paragraph in the middle of 245, please. The Court of Appeal found a way out of this problem, but holding that the sentencing judge, when adjourning the question of the cost of the confiscation proceedings after the conclusion of those proceedings, had exercised the common law power of the Crown Court to adjourn part of the sentencing process to a later date, applying Annesley. And then this, how far this can be considered a legitimate approach is open to question. The court in Annesley was not taking steps which contradicted an express statutory provision. And then I think this is Professor Spencer, I think we see elsewhere in the papers this is attributed to him.
Is it not Dr. Thomas?
Dr. Thomas, forgive me.
I think we see that on page 241 at the beginning of the report.
Yes, of course, we do indeed, my lord. I'm sorry. But the court, then we have section 15.4, and we say with great respect, Dr. Thomas is, of course, correct, and there are numerous places in which we see that. And my lady, my lords, we first draw attention to the House of Lords case of Senegi, because there were two possible answers by the respondent, by the prosecution in Senegi. Forgive me, let me go slightly further back. In Senegi, the Crown Court judge passed a confiscation order outside the statutory limit, which could only be extended if he had found exceptional circumstances. The Crown Court judge freely admitted that he would not have found exceptional circumstances had his mind been drawn to it, and thus, with some misgivings, nonetheless imposed the confiscation order. Their lordships in the Court of Appeal allowed the appeal because it was outside the time limit, and in the House of Lords, their lordships had two arguments mounted in appeal against the Court of Appeal's dismissal of confiscation order. The first was that these time limits are not mandatory, they are directory, to couch them in the language that we all used before Soneggi. And that is the basis of the decision in Soneggi, overturning the Court of Appeal, reimposing the confiscation order. But the other argument that was advanced, and this is clear from the speeches of their lordships, the other argument was advanced was the argument which the Court of Appeal in Constantine applied to reach their decision, namely there is a surviving common law power to adjourn part of the sentence. And it is our submission that, in fact, if one looks at the speeches of their lordships, they are all entirely clear that once there is a statutory time limit, one cannot avoid it by harking back to some previous common law time limit, common law power to adjourn sentence which would have applied absent the statute. And if we start with paragraph 27 of Soneggi, please. Lord Steyn, 27 at page 261, forgive me, 261 in the bundle numbering. And at 27, for the sake of completeness, I deal briefly with two remaining aspects which were debated. First, lower courts have accepted that in parallel to the statutory confiscation postponement proceedings, there exists a common law jurisdiction to adjourn confiscation proceedings. In my view, section 72A3, the time limit section, rules out such coexisting powers. I would rule there is no such common law jurisdiction. My lady, my lords, Lord Roger makes the same point. If we may go to paragraph 33, bundle numbering 263, please. And at 33, his lordship adopts the reasoning of Lord Steyn and then says, lower down, in the middle of that paragraph, please, I respectfully agree with him that the court had no common law power to postpone the determination to obtain information. Lord Cullen made the same comment in the same judgment. His speech, please, is at paragraph 50, bundle numbering 267. Bundle numbering 267 at paragraph 50. Lord Cullen said, I do not consider there is a common law power to postpone determinations which coexists with the power provided for in section 72A. So we do say with great respect that on this aspect, the Court of Appeal in Constantine fell into error, and although it is junior authority, if one's allowed to call Lord Judge that, if one goes briefly, please, to the case of Gordon, which was, of course, relied on in the case by the Court of Appeal in the case of Constantine. The case of Gordon starts at page 297. Bundles, please. It's a decision of a constitution of the Court of Appeal presided over by the President of the Queen's Bench Division, Sir Igor Judge, as he then was. Gordon concerns a number of cases brought together because there was a time before the legislation changed where if someone had served 3 months or whatever on remand awaiting sentence, unless the judge said the 3 months you serve shall count against the 5 years or whatever I impose, it didn't. And that, of course, filled the Court of Appeal's diary with cases where judges hadn't said that but meant to say it, and there were various means deployed to correct it. In the end, the case of Gordon, before the law was changed again, the case of Gordon said a judge should simply say time on remand shall be allowed. I think it's 56 days, but if I'm wrong, it can be corrected later. But in passing, as it were, Lord Judge, forgive me, Sir Igor Judge, who then was, does deal with this point, and if we go to paragraph 41, please, of the judgment, page 307 in the electronic bundle, 307 in the electronic bundle, it's the judgment given by the President. The principal issue raised by the Crown's appeal in these cases is whether, assuming the judge had not been entitled to postpone the terminations, the confiscation orders were invalid. They're talking about Seneji, obviously. The answer was that delay beyond the 6-month limit did not of itself nullify or an otherwise properly made confiscation order made after the 6-month limit had elapsed, or for non-compliance with the preferred statutory sequence that the confiscation proceedings and orders should precede the remaining sentencing decision. And then this, for present purposes, we take note that the consequence of the detailed legislative arrangements governing possible postponement of confiscation proceedings removed the common law powers of the court to order adjournment of the confiscation proceedings. So there we say, with respect, the case of Gordon, which of course the Court of Appeal and Constantine rely upon, actually does not support their lordship's conclusion. We make a further point which probably doesn't address the issue that my lady and my lords have sought to explore with us today, but can I simply give, it's our paragraph 14, it's page 58 of the bundle.
Just before we leave this,
I'm sorry.
It might be worth noting that paragraph 42 says that it's tempting to seek to apply Seneji to Section 155 of the 2000 Act. Now, Section 155 is the English provision corresponding to Section 56 of the Isle of Man Act of 1993.
Well, precisely so.
It's tempting and treats Seneji as authority which enables the court to vary or rescind a sentence beyond the 28-day limit. However, that route is not available to us, Menacau.
Well, yes. So, my lords, my lady, forgive me, as we're there, at the foot of the page at paragraph 43, the President, Sir Eagle Judge, as he was, touches upon the crucial importance of finality. We have rather taken that as read in our submissions because it is a central plank of the Isle of Man Appeal Court's decision, but nonetheless, as my lords and my lady raised this as particular focus, foot of page 307, Sir Igor Judge makes the point that appears throughout these papers that finality is an important element of the criminal justice system. Forgive me, my lords, my lady, a point we make on this topic, but it may not engage, I accept at once, with the more profound point the court's asked us to turn our minds to, is the case of Dorian. And may I summarise it, because I don't think it engages with the point I've been asked to deal with. Even if there is a common law power of adjournment, someone has to say they're adjourning the sentence. You cannot simply retrospectively create an adjournment if no one adjourned it. We deal with it at paragraph 14 of our case, bundle 58. The case of Dorian is at page 315. I don't think this engages with the point I've been asked to.
Just noting on page 308, Dr. Thomas is referred to on the point that you can adjourn part of a sentence, which is the point he made in the commentary on Constantine.
My lord, yes. And Annesley, again...
There's no way one can treat costs as part of the sentence, is there?
Well, yes, one can with respect, but the distinction between parts of the sentence which have a statutory time limit and those which don't, the point that Dr. Thomas makes in his criminal law review of the case of Constantine. So I think it is part of the sentence, I have to concede at once, but not of a statutory limit. And the case, I'm happy to take the court to it. The other case that deals with this, it's the case of Annesley. It is an earlier case. It makes the same point again. Annesley, I think, is about a disqualification from driving, which was done later on. And the court makes the point within Annesley that a court does have a common law power to adjourn the sentence. We had, of course, but not where there is, we would submit, not where there is a statutory time limit placed upon it. Annesley is a case from 1975. Lord Justice Bridge, as he then was, presiding, and forgive me, it's at page 294, insofar as the point is addressed explicitly, perhaps it isn't really, it's within page 294, but Annesley gives us the discussion that is then referred to by Dr. Thomas and taken up by Sir Igor Judge, as he was in Gordon, which itself confirms the view of the House of Lords in Soneggi, that you can have a common law power to adjourn sentence. One can have a common law power to adjourn sentence, but not if there's a statutory time limit. Otherwise, the statutory time limit would be completely pointless. My lords, my lady, I return to our skeleton, our case, to see if there are further matters on this part, which the court has sought to explore.
Yes, we just wanted to make sure that this point was adequately covered. We're not in any way trying to dissuade you from addressing us on the other points.
I could do them both in a few minutes each, if I may, but can I just finish? Because the obvious counter to the submission we make as our ground three, is that, well, sometimes time limits aren't what they seem. Forgive me, my paraphrasing, not the courts, and Soneggi is an example of that. We have attempted to list at page 56, it's paragraph 11 of our case. We have attempted to list at page 56 of the bundle why we say, while Soneggi, of course, is good law on extending on the fact a confiscation order is made outside the limit does not necessarily render it invalid. While it's good law on that, it ought not to apply to a costs order, and we've set that out at our paragraph 11. That seems to me relevant to the matter that my lords and my lady have asked us to explore. May I then really just in a few minutes address the other two grounds, unless the court doesn't wish me to do so. And again, they are set out, so I will simply go through them briefly, if I may, and finish, unless I can help further, very much within our allotted slot, even if I'm doing it in a different order. We say the Isle of Man Appeal Court was correct, and although they did not articulate their reasoning for being correct in the same terms that we argue it, they did it on two bases. Firstly, they said the judge had resolved the issue of costs or no costs at the hearing when it was discussed in November 2014, and had no power to revisit it 10.5 months later when he made the costs order. We say the appeal court quite clearly also relied, even if it was an order, they also relied on the fact fairness meant the prosecution should not be allowed to use Section 56. We set this out in detail, and my Lord Reed has been kind enough to say the case is set it out, so I'll just go to two documents, if I may. The conversation at court on the 26th of November 2014, it's at page 96 of the bundles. This is not the day of conviction. This is a month later when both parties have been able to gather their thoughts. They have come back for the sentencing hearing. A timetable has been set down for the confiscation hearing. And of course, the key passage starts at line 16 on page 96.
Now, the context of this, as I understand it, is that the defendant is no longer in the dock.
Yes, I think he's gone. The passage we see above is actually the tail end, and forgive me if we cut it off, we're trying to focus on the relevance. The passage above is the tail end of someone else being sentenced, because actually he gets 9 years and that person gets 2.5.
Yes.
But yes, he has been taken down or gone down,
Yes.
and at that stage is not represented.
He's not represented either. So he has no knowledge of this conversation.
No.
Right.
The judge says, are there any other orders the prosecution seek? Prosecution counsel, no. Disqualifications has to be dealt with differently. Then the judge again clarifies it. That is what I understood to be the position. In the circumstances, there will be no other orders in relation to costs or anything of that kind. The prosecution counsel, Mr. Benson, says no. We have two submissions, essentially. Firstly, that is an order of the court. The judge does not say formally, therefore, I shall order no cost to be paid, but for a variety of reasons, we say that clearly is an order of the court. Some of those reasons are articulated in the Isle of Man Appeal Court judgment, which I'll go to in a moment if I may. But we also note this all comes back to life when the prosecution seek to use Section 56 to vary it, and implicit within trying to use that section is it's an order of the court. Otherwise, the section doesn't bite. Can we go?
If it's not an order of the court, you don't need Section 56.
Precisely not, my lord. Precisely not. We would say the problem with that is an issue is articulated, resolved, and if that does not amount to, quote, an order of the court, unquote, it can be reopened, I suppose, at any time, and certainly in any later hearings.
Do you say this is a pronouncement in open court?
Yes. Yes. And in fact, may I go, and I really will do this shortly because I appreciate the focus of the court's interest. I'm sure the court's interested in all the case, but the interest in today's hearing. The appeal judgment is within our bundle, of course. It starts at page 67, but the passage I would take the court to starts at page 78, please. It's paragraph 42, page 78. In our judgment, the prosecution's deliberate decision not to apply for costs prevented it from making a subsequent application for costs. Now, we say within that sentence there are two aspects. One is, as a matter of law of jurisdiction, it presented it, functus, as we traditionally one might say, and secondly, it would not be fair to now allow the prosecution, it was not fair for the judge 10.5 months later to allow the prosecution to reverse that stance. Can we go, taking it shortly across the page to page, paragraph 46, page 79, please.
And you say that it wouldn't be fair to allow them to alter their stance even though the defendant was not aware of the stance that they had adopted?
Yes, the two aspects. One is whether there's any jurisdiction to do so, and my Lord appreciates that. Secondly, maybe it's not so much fairness to the defendant, it may be, and I think this is more close to how we express it in our written case, it may be that the Isle of Man Appeal Court realise which is more important in a particular instance, whether it is that the government prosecution should acquire the costs, or whether the prosecution should be obliged to act efficiently, competently, and timeously. And in the end, we say the court comes down on the side of rules and regularity, and thinking that outweighs any public interest in the Attorney General having his costs paid by a defendant.
I mean, it sounds rather like a public interest argument.
Yes.
That there is a public interest in statements made by the prosecution in open court being binding on the prosecution, yes, in the absence of perhaps some exceptional circumstance.
My Lord, yes. Can we state...
Forgive me, do you say that it's an abuse of process to go back on that?
Yes. Forgive me, there's two strands. One is there any jurisdiction? If it's an order, it's not within Section 56, it's 10.5 months later, there hasn't been an error of law anyway. So on jurisdiction, we don't need to resort to that. But my Lord Jones is entirely correct. The second stance is, we put it slightly differently, if I may. An appeal court is entitled to say, this would not be fair, this would not be right, this would be an abuse. And they're entitled, with great respect, to regulate their own local prosecutors and say that we will demand certain standards of them and they will pay a cost if they do not meet those standards.
Thank you.
And if one looks at the language in paragraph 46, bundle numbering page 79, please, the foot of 46, the top of 46, the court says section 56 doesn't apply. Well, we agree it doesn't apply because we are...
Sorry, we're at paragraph?
Paragraph 46, forgive me. They say section 56 doesn't apply, perhaps because the appeal court doesn't regard it as an order. We, with great respect, disagree on that, but the timing means it can't apply anyway because we're 10.5 months later, very far outside the time limit. Then the court goes on to say this in the last 5 lines of paragraph 46, in any event, which we say must be understood to be an alternative basis for their decision. In any event, in our judgment, the prosecution should not be permitted to pray in aid, section 56, in the particular circumstances of this case. The prosecution failed to make an application for costs at the relevant time. Indeed, the prosecution indicated they would not be making an application for costs. And that, we say, does sound far more like, to use the phrase my Lord Reid mentioned just now, a public interest declaration rather than a jurisdictional matter. And simply as we are here, could I ask my lady and my lords to go over the page to page 80 and look at paragraphs 50 and 51. And this really reverts back to our first point. Although it's not couched in these terms, it is an order. And paragraph 50 and 51, we would say, actually support the contention that the judge saying there will be no order as to costs is actually an order. Paragraph 50, although we note the order made by the court did not expressly record any determination that there was to be no order as to costs, we've concluded such fact is not decisive. Had the appellant or Mr. Kane suggested, that was his lawyer at the time, at any time before the 17th of December 2014, that's when an email from the prosecution changing their minds comes through, that the order should be amended to include such a provision, we can only assume that consistent with what Mr. Benson had told Deemster Burkitt, such amendment would have been consented to by Mr. Benson and made by Deemster Burkitt.
So if that had happened, would the order have said no orders to cost?
To be irritatingly pedantic, my lord, it probably should have been, probably should have been the order is there will be no cost paid, because no order gets confusing if we're saying it's actually an order. Forgive me.
But costs couldn't be dealt with at that stage anyway, could they?
Well, they couldn't, and we have cited and seek to distinguish a case on that. Well, there are 2 submissions we have in respect to that, my lord. Firstly, it depends. If an order involving payment includes an order there won't be any payment, which Constantine said it did, then my lord's right. But if, on the contrary reading, an order there shall be no costs is not an order involving payment, then that could be made before the confiscation hearing. Secondly, even if the order should not have been made then, that would not be a basis to declare it invalid. And the Court of Appeal found this in the case of, forgive me, I think it's Parvinder, I pronounce it wrong. The Court of Appeal found this in the case of Pavanata Taylor, a fine imposed out of sequence, as it were, with a confiscation was nonetheless valid. Well, we would say this must be a two-way street, so to speak. If the wrong sequence doesn't render things invalid, then if there is an order no cost should be paid, it's not rendered invalid by being made at the wrong stage. And thirdly, if it was an error of law, well, Section 56 would have allowed its correction. It wasn't corrected. And fourth, we would submit, at the risk of provoking an argument of more profundity than I have time to deal with, that the orders of criminal courts need to be voidable rather than void ab initio, Otherwise, there are terrible problems, for example, with someone in prison being able to use self-help to resist their incarceration and free themselves, whereas in fact they should go to the Court of Appeal Criminal Division to resolve the matter. So for all those reasons, my Lord, we say that should not be fatal.
The rule requiring confiscation to be dealt with first actually requires the court to take account of the confiscation order before making any order involving any payment by the defendant. So if you were making an order that there would be no award of costs, then that wouldn't be an order involving payment by the defendant.
We agree entirely. The Court of Appeal and Constantine disagreed diametrically.
Yeah.
That's the point you make in our case. And of course the reasoning is, if one is requiring a defendant to pay costs, one ought to know if he has any money first, and the confiscation proceedings address that. Whereas if one is saying the defendant need not pay costs, then it doesn't really matter whether he can afford to pay costs or not. Forgive me, if I may go back to the appeal court judgment at paragraph 51 on page 80. If there is a lesson to be learnt from the matters set out above, it is that when a prosecution or defence advocate informs the court no application for an adverse cost order is to be made, such should be recorded in the court's order. Now, if we bear in mind that the court's order, quote unquote, is the words that leave the judge's mouth, not what is written down later, and there's authority on that within our case and within the bundle, then we do say the appeal court is going very close to saying, although it wasn't written down, the judge's exchange with Mr. Benson was indeed an order. And if it is an order, then the appellant very properly concedes Section 56 could not act because it's much too late. It's 10.5 months, not 28 days. My lords, my lady, I'm conscious of the time. I'm conscious I was going to do our first two grounds in brief. Unless there are matters the court would like me to deal with, those are all our submissions.
No, thank you very much indeed, Mr. Benson. Ms. McGuinness.
Lady, just by way of preliminary, the appellant takes no issue with the Section 56 issue that's been raised. In fact, as my learned friend has indicated, the appeal court in the Isle of Man ruled against his submission, and therefore perhaps there ought to have been a cross-appeal, but I don't take any issue on the absence of a cross-appeal. And more relevantly, the appellant does not take any issue at all on the fact that the third submission, the Section 2A10 submission, was not raised at all either before the Deemster or before the appeal court. Yes. Can I start then, please, with the new point? If we go back, my lords, my lady, to Section 2A10, which we have at page 151 of the bundle. In this case, it's not, the attorney submits, apt to describe the costs order that the Deemster made on the 14th of October 2015 as a variation of any order that he had made on the 26th of June 2015, which is when he made the confiscation order. Variation suggests some form of amendment. Clearly, if on the 26th of June, when the Deemster made the confiscation order, there had been no consideration at that time as to whether or not there should be a costs order, in other words, the issue had not been raised, then clearly, if subsequent to the 26th of June 2015, the court were to make an order such as a costs order, that would clearly fall within Section 2A10, and the time limit would be engaged. But the issue as to whether or not there should be an order for costs had been a live one for many, many months. If my lords and my lady go to page 91 of the bundle, there is an order that the Deemster made dated the 19th of December 2014, following the email exchanges which you have later on in the same part of the bundle, adjourning any application for costs to a hearing on the 6th of May. That was intended at that stage to be the adjourned hearing for confiscation. If one then turns to page 92, there was a further order made by the Deemster on the 3rd of March 2015. And one can see from paragraph 1, the confiscation hearing listed on the 6th of May is hereby vacated. Now, I accept there is no reference in this order to costs being adjourned, but it's apparent from page 91 that a consideration as to whether or not there ought to be a costs order was a live issue on the 19th of December following the Crown's application by way of email, and was still a live issue on the 3rd of March. We then have at page 93 and 94 the order that the court did make on the 26th of June, and that part that we see on page 93 is the court's order, in fact agreed by consent, setting out the terms of the confiscation order. And if one then turns to page 94 at the top, the court further ordered on the 26th of June that the prosecution's application for costs be adjourned. At that stage, it's clear the Deemster considered it might have been dealt with administratively, but clearly allowed for the fact that if required, there would be a hearing. And that indeed was the hearing that commenced on the 12th of October and concluded on the 14th. And the only purpose of the hearing that commenced on the 12th and concluded on the 14th was a consideration of the prosecution's application for costs. And therefore, going back to the words of section 2A10, the issue of costs was actively under consideration. The court clearly had not determined it one way or the other. And what the attorney submits is that from the 19th of December at the very least, which was prior to the making of the confiscation order which followed in June of 2015, the court was adjourning, having sentenced the respondent to his term of imprisonment. The court was initially adjourning both confiscation and costs until the hearing of the 26th of June. And after the hearing of the 26th of June, the only matter that was still live was the cost issue. And that is covered by page 94. And the attorney submits that adjourning part of the sentence, because it's agreed between the parties that an order for costs is part of the sentence. That is made clear, in fact, by the Court of Appeal in Constantine. If my lords and my lady go to Constantine, which is at tab C9, starting at page 231, at the very top of page 239, at paragraph 27, the court referred to the So page 239, my lord, C7. Constantine, page 239 of the bundle, paragraph 27 of the judgment at the very top of the page. By reference to the earlier authority of Hayden, an order that a defendant should pay all or part of the prosecution costs is itself an order the defendant should pay, is itself part of sentence, because it is an order made by the court when dealing with an offender in respect of his sentence. That was the first part of the court's analysis, so costs is part of the sentencing process. Second, by reference to Annesley and Gordon, that the court has, here we were dealing obviously with Crown courts, the point in Annesley, which my lords, my lady will find behind tab C11 at page 291, was whether a Crown Court, then a relatively new development because the Crown Courts had been introduced from January 1973, the issue in Annesley was whether the Crown Court had jurisdiction at common law to postpone the passing of the whole or part of a sentence if circumstances made it necessary, and the court in Annesley held that the Crown Court did have such a power. It's dealt with in terms at the bottom of page 294 of the bundle, letter H of the judgment. The Crown Court still enjoys the common law jurisdiction vested in its predecessors to put off passing the whole of a sentence, or indeed part of a sentence, if the circumstances make it necessary. That was relied on by the Court of Appeal in the case of Gordon and others, which is behind tab C12 starting at page 297. And my learned friends indicated what the problem was. The problem, in fact, at the time of Gordon was not simply only Crown Court judges failing in passing sentence to make any reference to giving credit for time spent on remand in custody, but very often at the time that sentence was being passed, it wasn't clear what the proper calculation of the numbers of days was, and therefore one of the issues was that the Crown Court judges were, in passing sentence, announcing that X number of days would count towards sentence, and then when further information was acquired, it was discovered that it was Y number of days, and that the period would have to be varied. And in many instances, that information was only coming to light after the period set out in the 28-day slip rule had passed. And so, faced with that difficulty, the court in Gordon, in which the judgment was given by the President, in fact, applied what it called the Annesley principle. If my lords, my lady, turn to page 308, in fact, they adapted the point from Dr. Thomas himself, who'd said that there was a path, a way to overcome the problem that was being faced, which did not require time-consuming and obviously agreed applications for leave to appeal against sentence to the Court of Appeal. And paragraph 46 at the bottom of page 308, the President indicated that in most cases it should be possible to get to the right number of days within the 28-day period that was allowed, but at the top of page 309, he went on to say, but even if delayed beyond that period, it would be permissible for the Crown Court to deal with what is no more than the final implementation of its order. This would not be a variation or rescission of sentence. It would merely represent the conclusion of an adjourned part of the sentencing process.
Well, it might be said against you that in the present context, what we're dealing with isn't the final implementation of an order, but it is, on the other hand, a variation of sentence because that's what the statute, what Section 2A10 tells us it is.
My Lord, yes, but the submission of the attorney is that where the sentencing process has consciously been adjourned, or a part of the sentencing process has been adjourned, then the principle in Annesley, which was applied on not dissimilar facts by the Court of Appeal in Constantine, is the correct one. Constantine is really the critical decision on this new point.
But before you go to that, can I just understand
Yes.
how it fits into the wording of the Act that we're concerned with? 2A10 begins where the court has sentenced the defendant. Is your argument that that is not satisfied? This defendant has not been sentenced?
Well, he has been sentenced, but the sentencing process, my lady, has not concluded.
So does it fall within has sentenced or not?
Sorry?
Does it fall within the words has sentenced or not?
Yes, it does, if what is then being contemplated is a variation of the sentence. But the sentencing process has not been completed. What Section 2A10 is referring to, when it says has been sentenced, is clearly a reference to has been sentenced in respect of confiscation. Because Section 2A10 is engaged where there has been a postponement permitted by the statute.
Surely not. It's where they haven't dealt with confiscation, they can go on to sentence.
Yes, but 2A10 is engaged where there has been a sentence within the specified period, which has to include confiscation. So Section 2A10 can only be engaged after the end of the specified period, which was the period during which confiscation was postponed. So ipso facto, 2A10 is only engaged once an order for confiscation has been made, or perhaps not made, because that then brings an end to the specified period.
Can I just be sure I'm understanding this? In 2A, subsection 1, what enables the court, for the purpose of enabling the information required for confiscation purposes,
Yes.
to be obtained, to postpone making the determination of the benefit on the one hand and the recoverable amount on the other for such period as it may specify.
Yes.
Okay. Then subsection 7, and we know that the court did that.
Yes.
And it did that in...
June.
Or did it not do it in November 2014?
It passed the sentence of imprisonment, but the specified period commenced in November 2014 and ended in June 2015.
Yeah. So subsection 7, wherever court exercises power under subsection 1, it may nevertheless proceed to sentence or otherwise deal with the defendant in respect of the offence or offences concerned.
Yes.
Now, we know that the court imposed a sentence of 9 years imprisonment. Was that a sentence falling within subsection 7?
Yes.
Right.
It was.
So if we go to subsection 10, wherever court has sentenced the defendant under subsection 7 during the specified period, now is that condition satisfied?
Yes, but only in respect, my lord, of the confiscation order, because the specified period commenced on the 26th of November when the Deemster adjourned consideration of confiscation.
But the sentence imposed under subsection 7 isn't a confiscation order.
No.
It's not the period that's critical here, it's whether it's a sentence
Yes.
within the meaning of the earlier provisions in the Section 2A.
Yes.
So Effectively, the question is whether the costs order was a variation of the sentence which was imposed when the 9-year imprisonment period was imposed.
Yes, I can see my Lord's point. Save that that, as it happens in this case, the sentence of imprisonment was not imposed during the specified period, because the specified period only commenced on the 26th of November, because the court had not concluded the sentencing process.
Well, I wonder, the court can't pass an ordinary sentence, imprisonment or a fine or whatever. It can't pass that sentence in a case where there are confiscation proceedings unless it postpones the determination under 2A, under Section 2A.
Well, it can, my Lord. It very rarely does, but it can deal with confiscation first and then sentence.
Yes. Oh, yes, quite. Yes. But unless it's going to deal with confiscation first, it has to postpone the determination under 2A before it can do anything else with the defendant, doesn't it?
Yes. It can actually postpone both the sentence of imprisonment, because the sentence of imprisonment can occur within the specified period.
Oh, quite. It might need, for example, to order reports before passing sentence.
Yes. In fact, it looks as though there was some form of adjournment following the date of conviction, which was in October of 2014, until the hearing in November. We don't have any evidence in the papers as to what was the cause for that adjournment.
Thinking back to the days when I used to do this, my recollection is that you wouldn't say, I'm sentencing you to 9 years imprisonment. Now, what about confiscation? You would deal with the confiscation issue first, and almost invariably, you would make an order postponing the confiscation proceedings to some future date.
Yes.
And you would then impose, if you were in a position to sentence, you would then proceed to sentence in the ordinary way.
Yes.
Now, if that's the order that you do things in, then does it not follow that the sentence of imprisonment is being imposed after the specified period has begun? Because doesn't it begin as soon as the order of postponement is made?
It would seem somewhat odd if that all depended on whether or not the court had first passed the sentence of imprisonment and had then adjourned for the confiscation period. My submission is that any time after the 26th of November is the specified period in this case. And before that specified period began, the respondent had been sentenced, certainly to his sentence of imprisonment.
Yes.
And what subsection 10 seems to be allowing, and this is the way it's been put by my learned friend, is that there is still 28 days after a confiscation order has been made to vary the sentence by adding one of the other financial penalties that are referred to in the Act.
Yes, I see. So far as the statute is concerned, you could. The only bar on sentencing is the bar in Section 2.5 to do with financial orders.
Yes.
So far as under the statute, you could perfectly competently impose the 9-year sentence first, then turn to the question of confiscation.
Yes.
Impose postpone the determination of it, fix a specified period, and the 9-year sentence would not then be one that fell within subsection 7 of Section 2A.
In other words, it's engaged after that. Yes.
Yes.
And what's the logic of that? As you said, it's very odd if it depends on which comes first.
It is very odd because the common sense answer is that, I suppose, the day after the date of sentence will be the first day of the specified period, because the court is saying from this point on we are postponing the determination of confiscation to a particular date, which of course it can then extend.
Yes.
And in, my lady, in Constantine, it's perhaps worth looking at the factual background to Constantine. Constantine is behind tab C7, starting at page 231. And one can see from the judgment of the Court of Appeal, and I'll move through the paragraphs on page 233, 26th of January 2009, we see in paragraph 2, he admitted the offences before the Magistrates' Court and was committed for sentence. 5th of March, paragraph 3, he appeared before the judge at the Crown Court and received his sentence of imprisonment. Paragraph 4, we see that at the conclusion of the opening of the facts, prosecuting counsel mentioned that he had a figure for costs should the court consider an order for costs to be appropriate. We can see there was no specific response from the judge, who then went on to pass sentence. We then see from paragraph 6 that at the same hearing, the 5th of March, a confiscation timetable was set. And that confiscation hearing, we see from paragraph 7 at the bottom of the page, took place on the 10th of December 2009, and the court made a confiscation order. At paragraph 8, prosecuting counsel raised the question of costs. By now, the costs could be divided into two. There were the costs of bringing the appellant, in that case, to court, the costs that counsel had mentioned at the hearing on the 5th of March, and also a further sum by way of costs expended by the Crown in connection with the confiscation proceedings. Yeah. And one can see from paragraph 9 that counsel for the defendant, the appellant, conceded at the hearing that his client would be liable to pay the rather smaller sum, I think it was about £2,500, that the Crown was seeking for the costs of the confiscation, but contested the Crown's application, which had been mentioned. Well, it hadn't really been an application at all. All counsel had done at the first hearing in March was to raise the question of costs. And one can see from paragraph 9 that the question of costs only was adjourned to the date of the 4th of February 2010, which was 7 weeks after the 10th of December hearing, and therefore, as the court later pointed out, outside the time limit set for these purposes for that legislation, section 15(4). And the court, in fact, then made a total order for costs of just under £9,000. Yeah. It was against that background that the court, having referred counsel to the relevant legislation, my learned friend has taken, my lords and my lady, to this at page 238 at paragraph 25, recording the submission of counsel that the costs order was invalid because it had been made outside the 28-day mandatory period. The court agreed at 26 that in the light of Menokal, that was an impassable hurdle. And then again, as my learned friend has taken the court to, at paragraph 27, the court analysed what it found to be the position, namely that at the hearing in December 2010, the court had adjourned, in its words, part of the exercise of passing sentence. And it relied in its findings on both Annesley and Gordon, saying that the principle at the bottom of paragraph 28 stated by Sir Igor Judge applied by parity of reason to the present problems. And went on to say that it concluded the action of the judge in adjourning the issue of costs on the 10th of December meant only that he adjourned the final stage of the sentencing process for a period of about 3 weeks outside the 28-day period in order to allow legal argument about the appropriateness to make part of a costs order. It says part of a costs order because the counsel for the defendant had not challenged the application for costs arising out of the confiscation proceedings. Those were the circumstances in which the court in Constantine ruled as it did. My lords, my lady, my learned friend submits that...
Can I?
Yes.
I just want to go back, if I may, to the point that was raised by my lady, which may be a very important point. We haven't yet looked at Section 2, subsection 4, and it may matter. We've seen that Section 1 is the provision that confers the power to make a confiscation order.
Yes.
Section 2, in subsection 1, requires before the court can make a confiscation order, the prosecutor has to have given written notice to the effect that it would be appropriate to determine whether it ought to make a confiscation order. Now, when was that notice given? Was that given on conviction or?
Yes.
Yeah.
Well, the practice can't be given prior to conviction because conviction is a. My lord, the practice tends to be that the notice is served on the date that the jury returns its verdict.
Yes,
that's certainly the practice.
My experience as well. So if that's right, that would have been in October, I think.
Yes, my lord, October 2014.
October 2014, okay. So, subsection 2, if the prosecutor gives the court such a notice, the court shall determine whether it ought to make a confiscation order. So that duty to make a determination would arise on the date in October.
Well, subject to subsection 3,
Yep.
that when considering whether to make a confiscation order, the court may take into account any information that's been placed before the court.
Yes. And obviously we're going to come on to 2A, which deals with postponement of the determination. But in principle, as soon as you have the notice, as soon as the court has the notice, the court is subject to subsection 2 and the duty to determine. Well, subsection 4, if the court determines that it ought to make such an order, then it shall, before sentencing, determine the amount to be recovered and make a confiscation order for that amount. So far, the court gets the notice. If it determines that it is not going to make a confiscation order, then it can just proceed to sentence. If it determines that it ought to make such an order, then it can't sentence the offender in terms of this provision until the confiscation order has been made.
Yes.
So, for example, the 9-year sentence couldn't be imposed until after the confiscation order had been
If the
made.
court follows that procedure,
Yeah.
yes, my lord, yes.
And subsection 5, we've seen earlier, simply requires account to be taken of the confiscation order before imposing any other pecuniary penalty. Right. Now, so moving on then to 2A, where the court requires further information before determining the critical elements, it may postpone making that determination for such period as it may specify. And that So when did it actually first do that? In November or in October?
We don't have a copy in the papers of any order that the court made in October. Mm-hmm. But if it followed, my lord, the usual process, the court would have made an order in October, for example, that the convicted defendant provide certain financial information, which he is obliged to do under the legislation.
Yeah. Yeah.
So can I just
Jonathan may be able to help me.
I'll purely to try to help on the chronology and the history of this. If one looks at the discussion at the sentencing hearing at page 97 of our bundle, and forgive me to interrupt, I hope it helps.
Yes.
It is clear the judge has already set down a timetable before passing the sentence of imprisonment. And forgive me, this maybe, if one looks at Mr. Benson on 97, so it doesn't, I accept, shed light on whether that's in October or November, but it's clear the judge has addressed a timetable and therefore an adjournment before he passes sentence, which is on the preceding page.
Right.
I'm sorry if that takes us no further.
Well, the point her ladyship has identified is that subsection 10 is only triggered if the defendant has been sentenced under subsection 7 during the specified period. The sentence under subsection 7 the only candidate in this case is a 9-year term of imprisonment. So the question is whether the specified period had begun to run by the time that sentence was imposed. And that depends on whether the court had, by that time, already postponed making its determination on the confiscation order.
It seemed to me from Mr. Benson's comment on page 97 it must have done so because the orders have been set down and on the page before we have the judge actually specifying the periods of imprisonment.
It looks as if there are two decisions that the court has to make. The first one is it determines whether it ought to make a confiscation order, which is section 2, subsection 2. And the next one is where it's making a confiscation order, because that's what section 1 is all about. And 2A1 begins where a court is acting under section 1. So it's determined by then it's going to make a confiscation order, but it needs further information before it actually does it.
Yes.
So then it postpones, but that's two decisions.
My lady, it is, and one can occasionally have a case where if £100,000 is seized in cash from a drug courier, where one could actually confiscate, as it were, before sentence, but nearly always
I wonder if you may be agreeing a little too readily with what's being put to you. 2A1, the first determination is whether the defendant has benefited from any offence. There could be no question of imposing a confiscation order unless the court was satisfied that the defendant had benefited.
Forgive me, my lord, 2A1 precedes 2A1A, as I suppose it would, where the court's acting under section 1 but considers it needs more information before determining that.
Yes.
And also determine the amount to be recovered, which...
Yes. Before you can decide whether you're going to make a confiscation order, you have to know, in the first place, whether the defendant has actually benefited from the offence financially.
One might want to explore it because it seems possibly he may have done.
Yes. Yes, you don't necessarily... Because, the determination under 2 is whether it ought to make a confiscation order. The court can't be satisfied that it ought to make a confiscation order until it has actually ascertained that the defendant has benefited financially. Can it?
Well, I suppose this envisages the court might think it ought to make an order, but upon further inquiry, to its surprise perhaps, the court finds there has been no benefit or no realisable assets and thus declines to do so. It must be that decision is open because these matters are being explored. And
the other side of the equation is whether the defendant actually has any assets from which a recovery order can be against which a recovery order can be directed.
Yes, 2A1C.
But the words
where a court is acting under Section 1 in 2A1.
2A
encompasses, doesn't it, the Section 2.1 stage of trying to work out whether it would be inappropriate to make compensation?
Well, I think the court will have had to decide it will be appropriate to the extent. The court saying it will be appropriate to have confiscation proceedings is not finding inevitably there's been a profit, inevitably there's realisable assets. These are matters to be litigated. But forgive me, I rose to point out a page in the documents and I appear to be lured back in argument with my learned friends on this.
Yes, yes. Yes, Mr. Guinness.
My Lords, my Lady, my learned friend took you to Senegi.
Yes.
And certain passages in Senegi to advance a submission that the decision of the Court of Appeal in Constantine was wrong because the power to adjourn that the Deemster clearly exercised here in relation to costs is no longer a common law power that he has. The attorney submits that that is wrong because the statute that the court was considering in Senegi was not a power to adjourn part of a sentence. It was a specific power to postpone the determination of confiscation. And if my Lords and my Lady go to Senegi, which is at tab C9, starting at page 247, the statutory power, which the three of their lordships in Senegi said had effectively replaced a common law power, is that which is set out in paragraph 6 of the speech of Lord Steyne, which is at page 252 of the bundle. And it was then section 72A of the Criminal Justice Act 1988. And it's really the equivalent of the section we've just been looking at in the 1990 Isle of Man Act. It says...
you carry on, I'm sorry.
Yes. Where a court is acting under section 71, for which we read section 1, but considers it requires further information before determining whether the defendant has benefited from any relevant criminal conduct or determining the amount to be recovered in his case, it may, for the purpose of enabling that information to be obtained, postpone making that determination for such period as it may specify. So that was the statutory provision that Lords Steyne, Roger and Cullen were referring to. Lord Steyne dealt with it at the end of his speech at paragraph 27. He said that lower courts had accepted that in parallel to the statutory confiscation postponement proceedings, and that's clearly a reference is submitted to 72A, there exists a common law jurisdiction to adjourn confiscation proceedings. In my view, section 72A3 rules out such coexisting powers. Lord Roger also dealt with the point at paragraph 33 at page 263, where he said 5 lines down, I respectfully agree, that's with Lord Steyne, that the court had no common law power to postpone the determination to obtain information. That is, again, the 72A power to postpone to obtain information. And similarly, at paragraph 50, at page 267 of the speech of Lord Cullen, I do not consider that there is a common law power to postpone determinations which coexists with the power provided for in section 72A. But the power of adjournment that's applicable in this case is a different power. It's an adjournment of another part of the sentencing process, that relating to costs. And my learned friend took my lords and my lady on the same point to the judgment of the President of the Queen's Bench Division in Gordon, which is behind tab 12, starting at page 297. And he took my lords and my lady to paragraph 41 of the judgment of the President. But again, at the bottom, towards the end of paragraph 41, where the President says, for present purposes we must take note that the consequence of the detailed legislative arrangements governing possible postponement of confiscation proceedings remove the common law powers of the court to adjourn the adjournment of confiscation proceedings. So the dicta the Attorney General submits there are quite consistent, that the power to, the statutory word is postpone rather than adjourn, but whether one calls it a postponement or an adjournment, it's the same thing. Any power to postpone the making of the confiscation order has to be found in the statute. But the attorney submits, and this is the point that is established in Constantine, that strict power in the confiscation legislation does not exclude the common law power that Annesley and Gordon and Constantine remind us of, the power of a Crown Court to adjourn a part of the sentencing process. My lords, my lady, I can be equally brief, as my learned friend has been, on the remaining two issues.
Just, I mean, that's your, as far as Dr. Thomas's comment at page 245, you think he's got that wrong, do you?
Yes, I mean, I have to accept, of course, that it was Dr. Thomas's initial commentary that the Court of Appeal in Gordon relied on to, as it were, adapt the Annesley principle to the problem that was before the court. But obviously there, again, Dr. Thomas sets out subsection 4. Subsection 4 clearly has to be read with subsection 3. My lords, my lady will remember that I started my submissions by saying that this, on the facts of this case, whether or not to make a costs order had been a live issue since December 2014, it is not apt to describe the actual making of a costs order, consideration of which has been adjourned to allow for the parties to present their argument, as a variation of sentence. Although I have to accept that Dr. Thomas's comment is made in respect of the case of Constantine, which is the case that the attorney relies on for the establishment of this proposition. He goes on to say in the last paragraph of the commentary, the sentencing court in this case was not postponing part of the sentence, the question of an order for the payment of prosecution costs generally, but part of that order, the costs of the original proceedings. He makes the point there in his commentary about the two-way split. We don't have the same two-way split in respect of these proceedings. He goes on to say, and I don't seek to justify the Deemster's decision by reference to the principle set out in Synegy. In other words, I don't seek to submit that based upon Synegy, that if section 2A10 applies, one can simply say it's directory rather than mandatory, to use the old-fashioned language. Because there is a difference between the approach that the court took in Synegy, where it was focusing on the fact that the prosecution, that the court was under a duty to consider the making of a confiscation order, and that's why the court in Synegy held that if the court was under a duty to consider the making of a confiscation order, a procedural statutory time limit which had been breached on a proper construction of the Act did not mean that the court ceased to be under a duty to consider whether or not to make a confiscation order. Yeah. The position I accept is different here.
Yeah. It does seem really to depend on Constantine, because Gordon is distinguishable. That the sentence had been fixed as being a certain period of imprisonment, less whatever time had been spent on remand, and it was simply a question of ascertaining a number of days that had been spent on remand, and that's why the President said that it was dealing with what's no more than the final implementation of its order, not a variation or rescission of sentence.
Yes.
So it's distinguishable, because in this case, obviously, the statute tells us we are dealing with a variation of sentence, assuming that we're into subsection 10 at all.
I mean, if the committee took the view that Constantine was wrongly decided, then Gordon isn't going to help me.
No.
And my Lords and my Lady, the other two submissions that are in issue, or the other two issues before the committee, again, like my learned friend, I can deal with them, I hope, briefly. My learned friend submits, well, as the committee knows, the legal basis for the Deemster's ruling, which we find on the 14th of October, and it's to be found at pages 126 and 127, was a decision that he made on jurisdiction. One can see at line 13 on page 126, the Deemster refers to the jurisdiction on the island to make an order for costs, which is section 48 of the 1993 Act. And he goes on to say at line 17, before considering the merits or otherwise of the application, I do need to deal with a preliminary point which arose. And then he deals with the preliminary point over on page 127. At the top, he says that he asked counsel for the prosecution, advocate for the prosecution, if he was being asked to consider any other order in relation to costs, and received the answer, no. And he then goes on to say at line 11, it will be noted from the transcript and indeed from the formal court order of the 26th November that no order as to costs was made, no application had been made, no determination was sought, nor adjudication delivered. Therefore, section 56 didn't arise. And the crux of his ruling is at the end of line 15, in my judgment, the facts of the matter are that no order was made, no determination had been considered, and I can find no reason in law why Mr. Benson, on behalf of the prosecution, is now precluded from seeking an order for costs. That was the sole issue being dealt with there. The Deemster made it plain that he would go on to consider whether or not, on the merits, an order should be made. And as the attorney accepts in his written case, one factor that the Deemster was entitled to take into account in determining should an order be made, if so in what sum, was the conscious decision of the prosecution at the hearing on the 26th of November 2014 not to ask the court to make an order. It's interesting to see that the appeal court agreed on this point with the Deemster that in fact no order in relation to cost, to put it neutrally, had been made on the 26th of November. That's clearly set out at page 79 of the bundle, at paragraph 46 of the judgment of the court below, where it said that section 56 had no relevance to the circumstances of the case. He goes on to say, section 56 is limited to varying or rescinding sentences or orders. Deemster Burkett was not asked to vary or rescind a sentence or order in respect of costs because, and this is the kernel of it, there was no order made in respect of costs on the 26th of November 2014. And it's interesting that it was also the view of the Deemster that he, and he would be the best person to know, he had not made an order for costs. My learned friend submits that the exchange that he referred the committee to at page 96 amounted to an order for costs. But the Deemster dealt with that in his ruling on the 14th of October. At the top of page 127, it might on one view be read, page 96. The Deemster says, in the circumstances there will be no other orders in relation to costs or anything of that kind. Looked at simply as those words as they stand, it might be open to the construction that that is the Deemster pronouncing an order that there will be no order for costs made in favour of the prosecution. But it's clear from his ruling at page 127 that the words were used in an interrogatory fashion. He was asking a question, and therefore, the attorney submits, on the section 56 point, there was no order made. We both agree, my learned friend and I, that section 56 is of no relevance, but as the committee knows, it's because the attorney says no relevance because no order was made to be varied or rescinded. My learned friend's submission is not relevant because it was out of time, but an order had been made on the 26th of November. The appeal court clearly approached the question before them as one of jurisdiction. The complaint that the attorney makes is that the appeal court didn't in fact deal with jurisdiction at all. They simply contented themselves with saying that the mere fact that the prosecution had decided not to ask for costs and then changed its mind, as a matter of jurisdiction, meant that the Deemster could not thereafter make an order under section 48. But there is no reasoning with respect behind that. The Deemster was simply saying, I can if I want to. There is no ouster, but whether I do will depend on all of the circumstances. And I won't repeat what's in the written case, but the court's reference to the case of Tugel and others, and to the extrajudicial comment of Lord Neuberger, is in fact the beginning and end of its reasoning on jurisdiction, which the attorney submits was inadequate. My learned friend's response to the jurisdiction point is in fact, the attorney submits, a new rationalisation of the judgment of the Court of Appeal on a ground that is other than the ground on which it made its decision. The appeal court did not allow the appeal on the basis that it would be unfair to make the costs order. My own friend implicitly recognises this in paragraph 24 of his written case. He refers in support of his submission that what actually the court below decided was that it would be unfair, almost as a matter of discretion, to make an order at all under section 48. He prays in aid the last two sentences of paragraph 46 of page 79 of the bundle. The difficulty of that is that the last two sentences are spoken of by the court in relation to section 56. The court had already determined that there had been no order made at the hearing on the 26th of November. And my learned friend says that it wouldn't be right for this committee to take a different view on the fairness of the order from that taken by the lower court. The attorney submits that the first instance decision on whether or not it would be proper, fair, to make a costs order, and if so, in what sum, was that of the Deemster. And the Deemster made it plain that having decided jurisdiction in favour of the prosecution, that was not the end of it. He would then go on to consider the merits. So it was the Deemster who was the decision maker, and it was his decision on the merits, the exercise of his discretion that section 48 clearly gives him, that the attorney submits the appeal court should have recognised, rather than substitute their own view. But in fact, they didn't substitute their own view, because on any common sense reading of the ruling below, the appeal court did not come to the conclusion that we take a different view as to whether or not this was a fair costs order. They clearly come to one simple conclusion, said more than once in the judgment: the prosecution was precluded from making the application for costs once it had said in open court that it was not doing so. It did not consider, the Court of Appeal, the appeal court did not consider any question of prejudice, which surely would be a critical consideration, nor did it consider any of the particular circumstances that are set out towards the end of the appellant's written case. Because if the appeal court had been considering issues of fairness, it would have considered whether or not there was prejudice, it would have considered the means of the respondent, and it's clear from the confiscation process that he had the means. And finally, the attorney points to paragraph 39 of the ruling in the lower court at page 77 of the bundle. We start from the premise that the appellant's appeal on this issue is deeply unattractive. And it sets out what it then says thereafter would be good reasons for the Deemster having made a costs order against the respondent. But despite that unattractive nature of the appeal, that fortifies the attorney's submission that the appeal court did not decide the issue as one of fairness, but as one of jurisdiction and jurisdiction only. Does my lords and my lady have any further questions?
Thank you very much indeed, Mr. McGuinness.
We don't have it in writing from Mr. McGuinness. Summary.
We can always watch these proceedings.
Leave it.
What do you think? Yes. Yes.
And steal Mr. McGuinness's right of reply, given the varied
Yes.
chronology. Very briefly, if I may, on whether an order was made, a point my learned friend makes, which I didn't address already before. The Deemster made the observations, and the court's just been to it, but it's page 127 of the bundle. The Deemster, in deciding he had not made an order, said no application had been made, no determination was sought, nor adjudication delivered. In our respectful submission, none of those are unusual. Very often a court will make an order where the prosecution said, we don't want costs, there will be no application. If the judge therefore didn't have to determine costs, there would be no determination. If he'd had to make no determination, he wouldn't deliver an adjudication. But if he then said, therefore I shall order and it shall be written down, there will be no costs, that would be an order. So none of those really, we say, are determinative. We do rely on the language on the same point of the appeal court. It's at page 80 of the bundle, at paragraphs 50 and 51. So page 80, paragraphs 50 and 51. I've taken, my lady, my lords, them already. They are talking about the comments made by the Deemster in terms which we say actually amount to an order, even though I fully accept the appeal court don't accept that analysis. It could have been written down if anyone had asked. In the future, people really should write these things down at the end. On the discretion, on the decision to overturn the costs order, even if there was jurisdiction, we say the words in any event at paragraph 46 of the appeal judgment can only mean the court is moving to an alternative basis for their decision. Turning then to the third matter which has occupied the majority of our time today, just 2 points, if I may, in conclusion. Paragraph 2A, subsection 10.
Yeah.
My learned friend, in starting his comments, I think, and the misunderstanding may be mine, I think suggested that the phrase vary the sentence meant this only bites when there's been a previous, forgive me, my lord, when there's been a previous costs order or some such. In fact, if one reads the words that follow, vary the sentence by imposing a fine or making any such order, we would say, with respect, means vary a sentence, for example, of imprisonment by adding to it by saying there should be a fine as well. Yeah. If that is right, then the order made by the Deemster 10.5 months after the initial conversation about costs, we say clearly is affected by that time limit. And once there is a statutory time limit, and I mean no offence to my learned friend Mr McGuinness's more elaborate submissions, once Parliament has set down a time limit, there is the clearest authority from the House of Lords and Senegi, there's the clearest authority from the President, as he then was in Gordon, that a common law power can't survive a statutory time limit, for otherwise, with great respect, what would the point of a statutory time limit be if every time it was in place it could be avoided by simply endlessly adjourning? So, my lady, my lords, those are our answers, unless, of course, there are matters the court feels I should deal with, which I've not dealt with.
Well, thank you very much indeed. Well, we're most grateful to both counsel and to anyone else who may have been involved in preparing the parties' cases. We'll take time now to consider what advice we will humbly tender to Her Majesty.